Greetings and welcome to the latest episode of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners re-domesticate out of volatile, unfriendly legal and tax environments like the formerly golden state of California to more predictable pro-entrepreneurship, pro-growth jurisdictions. Today, we are reviewing a recent report by Zane Kahn, writing for the New York Post, entitled Tennessee Tries to Poach Paramount Skydance from California Amid $110 billion merger fight. I will then conclude by explaining how small and medium-sized business owners can use the same laws to their advantage to relocate their existing LLC or corporation out of California or another jurisdiction to Tennessee or another state the right way while keeping their existing federal employer identification number, contracts, bank accounts, credit history, and track record intact. But first, a brief introduction. My name is Chad Daniel Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law, and in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 12 professional licenses and certifications spanning accounting, tax, audit, financial planning, and of course, the law. My firm website is www.cummings.law. On July 2nd of this year, Tennessee Deputy Governor Stuart McWhorter sent a letter to the chief executive of Paramount Skydance. The letter invited the studio to consider moving its corporate headquarters to Tennessee and described the state's appeal in 3 concepts which resonate with equal force as between small business owners and large corporations, those concepts being fiscal discipline, low taxes, and predictable governance. That letter just so happened to arrive as the state of California was preparing to sue the studio. Days later, California Attorney General Rob Bonta, I don't know if I'm pronouncing that correctly, I frankly don't care, led a coalition of 12 state attorneys general in an action to block Paramount's acquisition of Warner Brothers Discovery, a transaction valued at roughly $110 billion. The Federal Department of Justice had already cleared the deal. 12 states decided otherwise. The antitrust trial is not scheduled until March of 2027, and until the matter resolves, Paramount faces a contractual ticking fee, as it's called, reported at an estimated $7 million per day, beginning October 1st. Paramount responded by opening exploratory talks to evacuate California. The reporting indicates the company has been in contact with Tennessee, Texas, and Georgia, to name 3 states. Roughly 30, not 13, but 30,000 jobs are attached to the combined enterprise, and the estimated annual recurring tax savings from relocation is $500 million. According to the report, the studio has also weighed selling its Los Angeles lots, each reportedly valued as high as $4 billion, to offset the cost of fighting the state. If you've been watching earlier presentations of Legal Bites, you know by now California hates businesses, large and small. Attorney General Bonta's answer to all of this was to call it blackmail. Now, that is really sloppy because blackmail has a defined legal meaning, and this is not blackmail. So that word deserves attention because it reveals the underlying premise. Blackmail describes a threat to do something you have no right to do. Choosing where your company domiciled is not blackmail. It is the ordinary prerogative of every business owner in the United States, exercised by small businesses as legitimately as by studios with 30,000 employees. When a state official describes a company's decision to leave as coercion, rather than as a market choice, that official has stopped thinking of businesses as participants and has started thinking of them as cows to be milked. Tennessee took a different approach, as, by the way, have other states like Florida and Texas. Tennessee wrote a letter, made a business case in business terms, and pointed to companies that had already relocated. Texas, Florida, and Georgia, to name a few states, have done the same for years. That posture treats a company as something you have to earn rather than something you already own. That means businesses are treated with the respect that they deserve. Florida and Texas, as I mentioned, start from the same premise. Neither Florida nor Texas impose a personal income tax, and small and medium sized businesses in both the Sunshine and Lone Star states usually do not pay any business income tax either. Both maintain regulatory environments built on the assumption that a business chooses to be there and can just as easily choose to leave. That assumption informs the behavior of the state authorities in a way that no statute can. Most companies watching this will never face a 12-state antitrust coalition or a $7 million daily fee, but the same lesson applies. The studio with 30,000 employees is now negotiating for the right to leave. A small company can simply pick up its stakes and leave immediately, but only if they follow the right procedures and work with a competent professional. Now, with all of this context in mind, redomestication is the lesser known legal process of transferring a company's state of domicile to a new state without dissolving it, without creating a new entity, and without triggering federal income taxes, but only when performed with the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. When performed by a knowledgeable and experienced professional, and that's an important caveat, the company retains its federal employer identification number, contracts, credit history, and bank accounts. That is to say, there is zero operational or financial disruption, but only if you get it right the first time. That is why it is imperative to work with a credentialed professional and save the DIY for home improvement. I have successfully completed redomestications from all 50 states, yes, including Tennessee, yes, including California, and for limited liability companies, partnerships, subchapter S entities, and subchapter C corporations. So if someone is telling you it cannot be done, what they are really telling you is that they do not know how to do it and can't be bothered to learn. Now, foreign entity registration is simply not the same thing as redomestication, because foreign entity registration, also referred to as foreign qualification among other terminologies, does not change the company's domicile. In fact, it does the opposite by keeping the company in the state you were trying to leave and merely adding another layer of compliance and tax obligations in the new state. All of that translated as follows. If you were trying to move out of California and you were considering foreign entity registration, you will not like the outcome because you will continue paying that minimum annual fee to the California Franchise Tax Board forever, and you will continue being subject to California law indefinitely. That is why foreign entity registration is not a sensible approach for changing the legal domicile of an existing business entity. Now, a traditional merger, which is also still not the same thing as redomestication, creates a new distinct entity in the destination state, may and often does require the issuance of a new federal employer identification number, and can trigger serious tax repercussions. Finally, dissolution should not enter the conversation at all, because dissolution terminates the company. Dissolution is the legal equivalent of the death penalty for a business. Dissolution is a we have failed, we are packing up and going out of business maneuver, not a relocation mechanism. Dissolution is often a taxable event, and when performed incorrectly, can expose the owners of the company to unlimited personal, yes, you heard me correctly, personal, joint, and several liability for the company's liabilities, known and unknown. This has bankrupted more than one small business owner who relied on incomplete or inaccurate advice. That is because the so called veil of protection no longer exists because the company no longer exists. If you think dissolution is a cute cost saving opportunity, you are in for a rude awakening. And if you have a so called professional suggesting dissolution as a relocation stratagem, please, I implore you, get better advice before you make a mistake you cannot undo. Redomestication, when paired with a change of personal residency and that is an important a reduction or outright cessation of business operations in California can reduce or even eliminate state tax exposure there for the entity and its owners. That's not my opinion. That is what the Supreme Court of the United States has said. And don't take my word for it, ask your CPA. Now is the time to consider acting before the California legislature in Sacramento considers changes to California law to hinder or even eliminate the option of redomestication. If you have questions regarding potentially redomesticating your existing LLC or corporation out of California or out of another state to Tennessee or to another state, please use the link in the description or in the bio for more information on this nuanced process and to schedule time for you and I to speak one-on-one about your specific scenario. Again, my name is Chad Daniel Cummings of the firm Cummings & Cummings Law, and I hope that you found this information informative. As always, the information in this presentation is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice definitionally must be specific to a particular set of facts and circumstances. Now, should you have any questions regarding this information or the content of any of my many earlier presentations on these topics, please visit my firm website at www.cummings.law, not .com, but .law to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.